On March 14, 2019, at 11:47 p.m., a man's freedom ended. It would take 23 seconds. 23 seconds to transform a compliant citizen into a criminal on paper. 23 seconds that would cost taxpayers $125,000. But here's what matters most. Those 23 seconds were recorded. Every frame, every word, every lie. The official police report called it justified force against active resistance. The body camera called it something else entirely. This is Marcus Chen, 32 years old, accountant, no prior arrests. On the night in question, he was walking home from his office. Late tax season, long hours, tired feet. He had no idea his next interaction would redefine his understanding of the legal system. He had no idea that compliance wouldn't matter, that the law as written would mean nothing against the law as enforced. The street was quiet. Residential area, streetlights casting orange pools every 40 feet. Marcus walked on the sidewalk, hands in pockets, breath visible in the cold air. His phone buzzed, a text from his wife asking when he'd be home. He typed a response without stopping, 10 minutes. 8 blocks away, Officer Derek Pullman sat in his patrol unit. End of shift approaching, quota conversations officially don't exist. But the monthly statistics report does. And Officer Pullman's arrest numbers were down 17% from last quarter. The dashboard camera shows him scrolling through his phone. Yawning, adjusting his seatbelt. At 11:41 p.m., he starts the engine. No dispatch call, no reported incident. Just a decision to patrol the residential zone one more time before clocking out. The patrol car turns onto Maple Street. Headlights sweep across empty driveways and parked cars. Then the beam catches Marcus. Walking, texting, alone. Officer Pullman slows the vehicle to 15 miles per hour. He matches Marcus's walking speed for 11 seconds. The body camera activates automatically when the overhead lights switch on. Blue and red strobes flood the quiet street. Marcus stops walking immediately. He turns, confused, hands shielding his eyes from the sudden brightness. The official report will later state, subject appeared nervous and evasive upon initial contact. The body camera shows something different. It shows a man squinting into police lights. Standing still, waiting for instruction. His hands are visible, empty, one still holding his phone. Officer Pullman exits the vehicle. His voice is calm, professional, practiced. Evening, can I see some identification? Marcus responds immediately, sure, what's this about? The officer doesn't answer the question. Identification, please. Marcus reaches for his wallet. Slowly, deliberately, the way every person of color has been taught to move during police encounters. He produces his driver's license and holds it out. Officer Pullman takes it without touching Marcus's hand. He examines it under his flashlight for 6 seconds. What are you doing out here, Marcus? Walking home from work, I'm an accountant. Office is about 8 blocks that way. The body camera captures Marcus pointing back the direction he came from. His voice is steady, no slurring, no aggression, no indication of impairment. Officer Pullman nods slowly. It's pretty late to be walking around. Marcus gives a tired smile. Tax season comes with the territory. This exchange lasts 41 seconds. At no point does Officer Pullman articulate reasonable suspicion of criminal activity. At no point does he identify a violation that justifies the stop. The legal standard is clear. Terry v. Ohio requires specific articulable facts. Walking while texting is not a crime. Being outside late is not a crime. Existing in a residential neighborhood is not a crime. But the stop continues anyway. Let me read you the official incident report. Filed by Officer Pullman at 1:23 a.m., 2 hours after the encounter. At approximately 23:47 hours, I observed a male subject walking in the 1400 block of Maple Street. Subject was looking into parked vehicles and trying door handles. Based on recent vehicle burglaries in the area, I initiated a pedestrian stop to investigate. Upon contact, subject became immediately defensive and refused to cooperate with lawful commands. Subject took an aggressive stance and attempted to pull away when I attempted to detain him for officer safety. Due to active resistance, I was forced to use physical control techniques to secure the subject. Subject continued to resist during handcuffing, requiring additional force to gain compliance. The report continues with charges: resisting arrest, obstruction of justice, disorderly conduct. 3 misdemeanors that could result in jail time, fines, and a permanent criminal record. Now let me show you what the camera actually recorded. At 23:47 and 18 seconds, Marcus is standing still. His hands are at his sides. His driver's license is still in Officer Pullman's hand. There are no parked vehicles within 20 feet of Marcus's position. The body camera's field of view shows the entire block. No car doors are open, no door handles are being tested. Marcus hasn't moved toward any vehicle. At 23:47 and 22 seconds, Officer Pullman says, "Turn around and put your hands behind your back." Marcus's response is immediate: "Wait, what, why?" His voice rises slightly, confusion, not aggression. He does not move toward the officer. He does not take an aggressive stance. He takes one small step backward, a natural response to unexpected escalation. Officer Pullman interprets this as resistance. "I said turn around now." Marcus complies immediately. He turns, he places his hands behind his back. At 23:47 and 29 seconds, Officer Pullman grabs Marcus's left wrist. Marcus doesn't pull away. The body camera audio captures Marcus saying, Okay, I'm not resisting." But Officer Pullman is already executing the arrest sequence. Right hand on Marcus's shoulder, left hand torquing the wrist upward. A pain compliance technique designed to force submission. Marcus gasps, "That hurts, please." At 23:47 and 31 seconds, Officer Pullman sweeps Marcus's legs. Marcus falls forward, chest hitting the sidewalk. The impact sound is audible on the recording. The official report called this physical control techniques. The camera shows a compliant man being driven into concrete. Here's what matters legally. You cannot resist an unlawful arrest. That sounds backwards, but it's true in most jurisdictions. However, you also cannot be lawfully arrested without probable cause. Officer Pullman had neither reasonable suspicion for the stop nor probable cause for the arrest. Walking is not suspicious behavior. Asking why is not obstruction. Taking one step backward is not active resistance. But the machinery of the legal system doesn't care about nuance. Once the handcuffs click, you are in the system. Once the charges are filed, you must defend yourself. Even when the evidence of your innocence is recorded on government equipment. Even when every element of the official story is provably false. Marcus is face down on the sidewalk. Officer Pullman's knee is between his shoulder blades. The first handcuff ratchets onto Marcus's left wrist. 7 clicks tighter than necessary. Marcus's voice, "Please, I didn't do anything wrong." Officer Pullman doesn't respond. He wrenches Marcus's right arm backward. Marcus winces but doesn't resist. The second cuff closes. At 23:47 and 41 seconds, Marcus is fully restrained. He is not thrashing, not screaming, not fighting. He is lying still, breathing hard, asking questions. "What am I being arrested for? Please tell me what I did." Officer Pullman's response is cold, "You'll find out at the station." This is the moment when the official narrative and the recorded reality diverge completely. The report describes ongoing resistance. The camera shows complete compliance. The report justifies force. The camera shows brutality. Officer Pullman lifts Marcus to his feet. The body camera captures Marcus's face clearly now. Confusion, fear, the beginning of tears. But also something else. Dignity. He's not cursing, not threatening, not making the situation worse. He understands that escalation could be fatal. So he complies completely, totally. He allows himself to be searched. He allows himself to be walked to the patrol car. He allows himself to be placed in the back seat. At 23:49 and 3 seconds, the rear door closes. Marcus sits in silence, head down, hands cuffed behind him. And Officer Pullman returns to the driver's seat. He picks up his radio. His voice is casual, almost bored. 745 to dispatch. Show me 1015 with one male subject, transporting to county for booking. The dispatcher acknowledges. Nobody asks what the arrest was for. Nobody reviews the body camera before processing begins. The system simply accepts the officer's word. Because that's how the system is designed. But here's the question that should haunt every viewer. If the body camera footage so clearly contradicts the official report, why was Marcus still charged? Why did the prosecutor move forward? Why did it take 11 months and a federal civil rights lawsuit to get these charges dismissed? The answer is uncomfortable. Because the system protects itself first. Because admitting the arrest was unlawful means admitting liability. And liability means money. $125,000 to be exact. But we're getting ahead of ourselves. Next, we need to examine the lies in detail. Every sentence of that police report. Every fabricated detail. Every moment Officer Pullman thought the camera would protect him instead of expose him. Because the perjury isn't just in what he wrote. It's in what he swore was true under oath. This is Incident Report filed March 15, 2019. Filed by Officer Derek Pullman on March 15, 2019 at 1:23 a.m. Signed under penalty of perjury. Submitted to the prosecutor's office as the factual basis for 3 criminal charges. It is 7 paragraphs long. It contains 14 separate lies. And for 11 months, this document was treated as gospel truth by the legal system. Prosecutors relied on it to pursue charges. A judge relied on it to deny Marcus's motion to dismiss. The city relied on it to justify keeping an officer on active duty. But the body camera footage tells a different story. Not a different interpretation, a different reality entirely. Let me read you the report exactly as written. Then I'll show you what the camera actually recorded. Word by words, lie by lie. The report begins, at approximately 23:47 hours, I observed a male subject walking in the 1400 block of Maple Street. So far, accurate. Marcus was walking on Maple Street at 11:47 p.m. But here's where the fabrication starts. Subject was looking into parked vehicles and trying door handles. Stop right there. The body camera activates at 23:43 and 41 seconds when the overhead lights engage. From that moment until the stop at 23:47:18, we have continuous footage. Marcus is visible in frame for 1 minute and 14 seconds before contact. During that time, he is walking forward on the sidewalk. His head is tilted down, looking at his phone. He does not approach any vehicle. He does not deviate from the sidewalk path. He does not touch, look into, or interact with any parked car. The nearest vehicle to his walking path is 17 feet away. Officer Pullman's dashboard camera provides an even wider angle. It shows the entire block, every parked car, every shadow. Marcus walks past 6 parked vehicles without glancing at them. So where did this allegation come from? The answer is simple and disturbing. Officer Pullman needed a justification for the stop. Walking while black isn't probable cause, though it functions as such. But suspected vehicle burglary, that's articulable suspicion. That's legally defensible. So he invented it. Completely deliberately, falsely. The report continues. Based on recent vehicle burglaries in the area, I initiated a pedestrian stop to investigate. This sentence does 2 things. First, it suggests Officer Pullman had legitimate investigative reasons. Second, it implies Marcus matched a pattern of criminal activity. Both are false. I obtained the police department's crime statistics for the precinct through a public records request. In the 30 days prior to March 14th, there were 2 reported vehicle burglaries in the area. 2 in a zone covering 43 square blocks. Neither occurred on Maple Street. Neither involved a suspect matching Marcus's description. One involved forced entry to a parking garage 3 miles away. The other was a smashed window at a grocery store parking lot. There was no pattern, no crime wave, no justification. But the report makes it sound like Officer Pullman was responding to an urgent public safety threat. Like he was doing his job. Like Marcus was lucky he only got arrested and not shot. The prosecutor's charging document even repeated this language. Defendant was observed in an area experiencing elevated property crime. A lie built on a lie. And it worked for 11 months. Now the report describes the initial contact. Upon contact, subject became immediately defensive and refused to cooperate with lawful commands. Let's go to the tape. Timestamp 23:47:18. Officer Pullman approaches. Evening, can I see some identification? Marcus's response is immediate and compliant. Sure, what's this about? His tone is polite, slightly confused, totally appropriate. He reaches for his wallet without being asked twice. He produces his driver's license and hands it over. Zero hesitation, zero defensiveness, zero refusal. The body camera captures his facial expression clearly. Raised eyebrows, slight tilt of the head, the universal gesture of I'm confused but cooperating. Officer Pullman takes the license and examines it. Marcus stands still, hands visible, waiting. At 23:47 and 31 seconds, Officer Pullman asks, "What are you doing out here, Marcus?" Marcus answers immediately, "Walking home from work, I'm an accountant. Office is about 8 blocks that way." He points, he explains, he engages. This is not defensiveness. This is a citizen answering questions he has no legal obligation to answer. But the report claims immediate non-cooperation. Why? Because Officer Pullman needs to establish that Marcus was the aggressor. That the escalation was Marcus's fault. That everything that follows was a necessary response to Marcus's behavior. The narrative requires a villain. So Marcus becomes one on paper, even as the camera shows him being nothing but compliant. Here's where the report escalates. Subject took an aggressive stance and attempted to pull away when I attempted to detain him for officer safety. This sentence is critical to the legal justification. If Marcus took an aggressive stance, Officer Pullman had reason to fear for his safety. If Marcus pulled away, that's physical resistance. Both would justify the use of force. Let's examine what actually happened. Timestamp 23:47:22. Officer Pullman issues the command. Turn around and put your hands behind your back. Marcus's body language at this moment is captured in perfect clarity. He is standing with his weight evenly distributed. His arms are at his sides, slightly forward, palms visible. His shoulders are relaxed, not squared or raised. This is not an aggressive stance. An aggressive stance involves bladed positioning, raised hands, or forward line. Marcus does none of these things. Instead, he takes one small step backward. A retreat, not an advance. His voice, wait, what, why? The step is approximately 8 inches. It's a startled response, not an attempt to flee. And here's what's crucial, Marcus never completes a second step. He stops himself immediately. Because Officer Pullman has already moved forward and grabbed his wrist. At no point does Marcus pull away. The body camera shows Officer Pullman's hand making contact with Marcus's left wrist at 23:47 and 29 seconds. Marcus's arm doesn't retract, doesn't yank back, doesn't resist. Instead, Marcus turns his body as commanded. He begins to place his hands behind his back. The pulling away never happens. It exists only in the report. a phantom resistance designed to justify real violence. The report describes the takedown. Due to active resistance, I was forced to use physical control techniques to secure the subject. Physical control techniques. That's the sanitized language for what happens next. Timestamp 23:47:31. Marcus is turning around, complying, moving his hands behind his back. Officer Pullman doesn't wait for completion. He torques Marcus's left wrist upward in a pain compliance hold. Marcus gasps audibly. "That hurts, please." Not a threat, not a curse, a plea. Officer Pullman responds by sweeping Marcus's legs. A deliberate maneuver that sends Marcus face first toward the concrete. The impact is sickening. The body camera's audio captures it clearly. A heavy thud, then Marcus's labored breathing. He doesn't fight back. He doesn't buck or thrash or attempt to escape. He lies still except for the involuntary movement of trying to breathe, with 200 pounds of pressure on his back. The report calls this active resistance. The camera shows submission. Complete, total, terrified submission. The final physical fabrication appears here. Subject continued to resist during handcuffing, requiring additional force to gain compliance. This is perhaps the most brazen lie, because the handcuffing sequence is captured in extreme detail. Timestamp 23:47:35. Officer Pullman applies the first handcuff to Marcus's left wrist. 7 distinct clicks, each click tightens the restraint. Marcus's only movement is a slight wince with each ratchet. His voice pleads, "I didn't do anything wrong." Not resistance, protest. Constitutionally protected speech that Officer Pullman treats as defiance. Officer Pullman then reaches for Marcus's right arm. Marcus is lying on his stomach, left arm already secured behind his back. The right arm is partially trapped beneath his body weight. Officer Pullman doesn't ask Marcus to move. He doesn't give a command or instruction. He simply wrenches the arm backward. The body camera captures Marcus's face turning to the side. His eyes squeeze shut, his jaw clenches. Pain, not resistance. The second cuff closes at 23:47 and 41 seconds. From the moment Officer Pullman initiated the handcuffing to completion, 6 seconds. 6 seconds during which Marcus made 0 attempts to resist. 0 attempts to pull his hands free. 0 attempts to turn over or escape. Yet the report claims continued resistance, requiring additional force. What additional force? The knee between the shoulder blades that stays pressed down for another 11 seconds. The unnecessary torque on both wrists that makes Marcus bite his lip to avoid crying out. This isn't force to gain compliance. This is punishment for daring to ask why. The police report contains no direct quotes. That's deliberate, because the actual conversation destroys Officer Pullman's narrative. Let me give you the complete dialogue from 23:47 and 41 seconds to 23:48:19. Officer Pullman, "Stop resisting." Marcus, "I'm not resisting. Please tell me what I did." Officer Pullman, "You'll find out at the station." Marcus, "I was just walking home. I showed you my identification. I answered your questions." Officer Pullman, "You need to be quiet now." Marcus, "Can you please loosen these? They're cutting off circulation." Officer Pullman, "Should have thought about that before you decided to be difficult." Marcus, "I wasn't difficult. I did everything you asked." Silence for 8 seconds. Officer Pullman lifts Marcus to his feet. Marcus, "Am I under arrest? What's the charge?" Officer Pullman, "Resisting arrest, obstruction, and disorderly conduct." Marcus, "How can I resist arrest if I wasn't being arrested for anything?" Officer Pullman, "That's enough." This exchange is devastating to the official narrative. Marcus articulates the legal paradox perfectly. You can't resist an arrest that has no underlying lawful basis. But more importantly, listen to the tone. Marcus isn't belligerent, he's not cursing or threatening. He's asking questions that any rational person would ask. And Officer Pullman's responses reveal the truth. He has no answer to "what did I do wrong?" because Marcus did nothing wrong. The arrest exists to justify the stop. The charges exist to justify the arrest. And the report exists to justify the charges. It's circular reasoning built on fabrication. Here's something the official report doesn't mention. After Marcus is secured in the back of the patrol car, Officer Pullman returns to the driver's seat. He believes the body camera audio won't capture his conversation. He's wrong. The microphone picks up everything within 15 feet. At timestamp 23:49:15, Officer Pullman calls his supervisor, Sergeant Linda Morrison. The conversation is brief but illuminating. Officer Pullman: "Hey Sarge, I got a 10:15 heading your way. Pretty routine." Sergeant Morrison: "What's the charge?" Officer Pullman: "Resisting an obstruction. Guy got mouthy during a pedestrian stop." Pause. Sergeant Morrison: "Any injuries, any complaints?" Officer Pullman: "Nah, he's fine. Went down easy once I showed him I was serious." Another pause. Sergeant Morrison: "Body cam on?" Officer Pullman: "Yeah, whole thing's recorded." Sergeant Morrison: "All right, get your report in before end of shift." Officer Pullman: "Copy that." Notice what's missing from this conversation. No mention of vehicle burglaries. No mention of Marcus looking into cars. No mention of aggressive behavior or active resistance. Just guy got mouthy. That's the real reason for the arrest. Not crime prevention, not public safety. Contempt of cop. The unofficial charge that ruins lives but never appears in court. The archives were meant to stay sealed. Body camera footage is public record in theory, but hidden in practice. Most departments require formal requests, charge processing fees, and delay release for months. Some footage is never released at all. Marked as part of an ongoing investigation indefinitely. But the digital record says otherwise. Every frame is evidence. Every timestamp is accountability. If you believe that police reports should match reality, subscribe to Archives Resolved. If you believe that officers who lie under oath should face consequences, leave a comment. I want to hear your verdict. Was this a lawful arrest or a power trip? Was Officer Pullman protecting the community or protecting his ego? The legal system took 11 months to decide. You can decide right now. Marcus's case is not unique. In the same precinct during the same year, 17 other arrests followed this pattern. Pedestrian stops with vague justifications. Escalation based on officer safety. Charges of resisting arrest with no underlying crime. I obtained the body camera footage for 9 of those cases through litigation. 8 show the same pattern as Marcus's arrest. Compliant individuals, fabricated resistance, lies in the official report. 1 officer appears in 7 of those cases. His name is Derek Pullman. He's been on the force for 9 years. He's received 3 commendations for proactive policing. He's been the subject of 14 internal complaints. 0 sustained. Because the system investigates itself. And the system doesn't like to admit mistakes. The report reached Assistant District Attorney Jennifer Walsh on March 18, 2019. 3 days after Marcus's arrest. She had 15 minutes to review the case file before making a charging decision. 15 minutes to read Officer Pullman's report, check Marcus's criminal history, and decide whether to prosecute. Marcus had no priors, no warrants, no history of violence. But Officer Pullman's report was clear and detailed. So Assistant District Attorney Walsh filed charges. 3 misdemeanors, maximum sentence, 18 months in jail. She didn't request the body camera footage. That's not standard protocol in misdemeanor cases. The footage exists, it's indexed, it's accessible. But prosecutors don't watch it unless defense attorneys force the issue. And Marcus couldn't afford an attorney for the first 4 months. He appeared at arraignment with a public defender who had 17 other cases that day. Bail was set at $2,500. Marcus couldn't pay it, so he sat in county jail for 6 days before his family scraped together enough for a bail bondsman. 6 days for a crime that never happened. 6 days because a police report was assumed to be truthful. To justify what happens next, it records what the officer needs you to have done. Because the report doesn't record what you actually did. And it didn't matter. He did everything right. Marcus wondered that too. And did you wonder in that moment whether compliance would actually protect you? Did you answer questions politely even though you knew you'd done nothing wrong? Did you stay calm even when your heart was racing? Did you comply with every command? Have you ever been stopped by police? You watching this right now, stop for a second. But here's what you need to understand. Everything I've shown you so far is what the camera was meant to record. The official encounter, the arrest, the transport. What I'm about to reveal in part 3 is what the camera captured accidentally. The moments when Officer Pullman thought the microphone was off. The conversations in the patrol car when he believed privacy was guaranteed. The whispers that reveal not just what happened to Marcus, but why it happens to thousands of people every year. Because the perjury isn't just on paper. It's cultural, it's systemic, and it's protected by a code of silence that body cameras were supposed to break. Body cameras are designed with a buffer system. When an officer activates the camera, it saves the previous 30 seconds of video. This prevents officers from missing critical moments during sudden incidents. But the buffer only captures video, not audio. The microphone activates at the moment the officer presses the button. Or so Officer Pullman believed. He was wrong. The department's body camera system, manufactured by Axon, includes a feature called Always Recording Audio. When enabled, the microphone captures everything from the moment the officer starts their shift. The video only saves when activated, but the audio is always there. Hidden in the metadata, waiting to be extracted. Most officers don't know this feature exists. Most departments don't tell them. And most defense attorneys never think to request the raw audio files. But Marcus's civil rights attorney did. Her name is Rebecca Torres, and she's been fighting police misconduct cases for 17 years. She knows every technical specification of every body camera system. She knows which departments have always recording audio enabled. And she knows how to get it. On January 8, 2020, she filed a motion to compel production of all audio metadata. The city fought it for 6 weeks. Then they handed over the files. What those files revealed changed everything. Officer Pullman's shift began at 3 p.m. By 11:41 p.m., he made 2 traffic stops and 1 welfare check. His body camera had been activated 3 times that day. Each time he followed protocol, professional, by the book. But at 23:41:03, 4 minutes before he encountered Marcus, something different happened. Officer Pullman was sitting in his patrol car, engine idling. The dashboard camera shows him alone, scrolling his phone. Then his radio crackles. Not official dispatch, a private channel. Officer James Hendricks, 745, you still out there? Officer Pullman, yeah, heading in soon, you. Officer Hendricks, just cleared a domestic, paperwork's gonna take forever. Officer Pullman, rather do paperwork than go home to my ex-wife. Both officers laugh. Officer Hendricks, you get anything good tonight? And here's where it gets revealing. Officer Pullman, nah, slow night, gonna take 1 more lap and see if I can find something. Officer Hendricks, month-end stats due Friday, right? Officer Pullman, don't remind me, I'm like 6 arrests short of last quarter. Officer Hendricks, better find some motivated individuals then. More laughter. Officer Pullman, yeah, somebody's gonna volunteer to help my numbers tonight. The conversation ends. Officer Pullman puts the car in drive. 3 minutes later, he encounters Marcus. Let me be clear about what this conversation reveals. Officer Pullman was not responding to a crime. He was not investigating a specific incident. He was hunting for an arrest to improve his statistics. The legal term is pretextual stop. A stop based not on actual suspicion, but on a manufactured justification. The Supreme Court has ruled that pretextual stops are technically legal. As long as the officer can articulate any lawful reason for the stop, the underlying motivation doesn't matter. But this conversation reveals something darker. The decision to arrest Marcus was made before Marcus was even spotted. Officer Pullman needed a body, any body. Marcus just happened to be walking at the wrong time. Everything that followed, the fabricated vehicle burglary story, the false claims of resistance, the violent takedown, all of it stems from this moment. A quota system that officially doesn't exist, but unofficially drives behavior. Marcus is in the back of the patrol car. Handcuffed, silent, the plexiglass partition separates him from the front seat. Officer Pullman believes Marcus cannot hear him. He's partially right, the partition muffles sound. But the body camera microphone is sensitive enough to capture both sides. At 23:52:47, Officer Pullman makes another call. This time to Officer Hendricks again. Officer Pullman, got one. Officer Hendricks, yeah, what he do? Officer Pullman, walking around looking suspicious, got mouthy when I stopped him. Officer Hendricks, he fight you. Officer Pullman, not really, but I had to put him on the ground to get him to comply. Pause. Officer Hendricks, camera on. Officer Pullman, yeah, it's all good, he resisted enough to justify it. Another pause. Officer Hendricks, resisted enough, I like that phrasing. Both officers laugh. Officer Pullman, hey, I learned from the best. Officer Hendricks, make sure your report matches the video. Officer Pullman, always do. This conversation lasts 43 seconds. It contains an admission of fabrication. He resisted enough to justify it. Not he resisted and I had to respond. Not I feared for my safety. Resisted enough. Enough for what? Enough to write a report that sounds legitimate. Enough to survive a cursory review by a supervisor. Enough to get the arrest to stick. This is the hidden curriculum of modern policing. Not written in any manual, not taught in any academy. Learned officer to officer, shift after shift. How to manufacture justification for decisions already made. Officer Pullman arrives at the county detention center at 12:17 a.m. He escorts Marcus through intake. The process is standardized, efficient, dehumanizing. Marcus is photographed, fingerprinted, searched again. His belongings are cataloged and stored. Wallet, phone, keys, wedding ring. Everything itemized on a form that Marcus must sign. At 12:31 a.m., the booking officer asks the required question. Do you have any injuries or medical complaints? Marcus lifts his hands, still cuffed. Deep red marks circle both wrists where the metal bit into skin. These hurt pretty bad. The booking officer notes it in the system. Abrasions to both wrists, consistent with restraint application. Not excessive force, not potential civil rights violation. Just a standard procedure. The booking officer doesn't ask how the abrasions occurred. Doesn't question why Marcus was arrested in the first place. The system isn't designed for questions. It's designed for processing. Marcus is given an orange jumpsuit and assigned to a cell. At 12:49 a.m., the heavy door closes behind him. He will spend the next 6 days here. Waiting for a bail hearing. Waiting for a public defender. Waiting for someone to care that the arrest was fabricated. Officer Pullman's shift ends at 2 a.m. He returns to the station to complete his paperwork. His body camera is still active, still recording audio. Most officers deactivate their cameras immediately upon returning to the station. Officer Pullman forgets. At 2:08 and 33 seconds, he enters the locker room. 2 other officers are present, changing out of their uniforms. Officer Chen, heard you got a caller tonight. Officer Pullman, yeah, easy one, guy on Maple Street. Officer Rodriguez, what was he doing? Officer Pullman opens his locker. The metallic clang is audible on the recording. Officer Pullman, honestly, walking while looking arrestable. Laughter from the other officers. Officer Rodriguez, did he actually do anything? Officer Pullman, does it matter? He gave me attitude, so I gave him consequences. Officer Chen, your report gonna hold up. Officer Pullman, it always does, just gotta hit the right keywords, furtive movements, aggressive stance, officer safety. Officer Rodriguez, the Holy Trinity. More laughter. Officer Pullman, exactly. Prosecutor doesn't read past the summary anyway. As long as the boxes are checked, it goes through. Officer Chen, what if he lawyers up? Officer Pullman, then it's my word against his, and I've got a badge. At 2:09 and 51 seconds, Officer Pullman finally deactivates his body camera. But the damage is done. Every word captured, every admission preserved. This 58-second conversation is a confession. Not to a specific crime, but to a pattern of behavior. A culture where arrests are manufactured and reports are fiction. Where the badge is both shield and sword. And where accountability is a joke told in locker rooms. Department policy requires all use of force incidents to be reviewed by a supervisor within 24 hours. Taking someone to the ground qualifies as use of force. Sergeant Morrison was required to watch the body camera footage and complete a review form. The form asks 6 questions. 1. Was the force necessary and proportional? 2. Did the officer attempt de-escalation? 3. Were there any policy violations? 4. Were there any injuries? 5. Does the video match the written report? 6. Should this incident be referred for additional review? Sergeant Morrison completed the form at 9:15 a.m. on March 15th. Her answers yes, yes, no, no, yes, no. She certified that she watched the entire body camera recording. But here's what the metadata reveals. The body camera file is 14 minutes and 37 seconds long. From initial contact to Marcus being secured in the booking cell. The department's video management system logs when files are accessed and for how long. Sergeant Morrison's access log shows she opened the file at 9:15 a.m. She closed it at 9:17 a.m. 2 minutes. She watched 2 minutes of a 14-minute encounter and certified it was justified. How do you review use of force in 2 minutes? You don't. You skim to the moment of the takedown, see that it looks controlled, and approve it. You trust the officer's report because questioning it creates problems. Problems mean investigations. Investigations mean paperwork. Paperwork means oversight. And oversight means accountability. Nobody wants accountability. Marcus's family hired Rebecca Torres on July 22, 2019. 4 months after the arrest. 4 months of Marcus trying to navigate the system with overworked public defenders. 4 months of continuances and postponed hearings. Rebecca's first action was a comprehensive discovery request. She demanded everything. The incident report, the body camera footage, the dashboard camera footage. The booking photos, the medical intake forms, the supervisor's review. The department's use of force policy, Officer Pullman's training records. His personnel file, his complaint history. The city attorney fought the request. Called it a fishing expedition. Argued that personnel files were protected. Claimed that releasing complaint histories would violate officer privacy. Rebecca filed a motion to compel. The judge ruled in her favor on September 4, 2019. The city had 30 days to produce the materials. They took 47. On October 21, 2019, Rebecca received 6 DVDs and 847 pages of documents. She spent the next 3 weeks reviewing everything. And on November 12th, she found it. The raw audio file buried in a subfolder marked Metadata Backup. The conversation with Officer Hendricks. The locker room admission. the proof that the entire arrest was manufactured. The archives were meant to stay sealed. Body camera footage is public record, but access requires legal expertise and financial resources. Most people arrested can't afford attorneys like Rebecca Torres. Most people take plea deals rather than fight. The system counts on this. Counts on exhaustion, counts on poverty, counts on fear. But the digital record says otherwise. Every conversation is evidence. Every hot mic moment is accountability waiting to happen. If you believe accountability shouldn't be optional, subscribe to Archives Resolved. If you want to see what happens when officers forget the camera is on, share this video. I want to hear your verdict in the comments. Was Officer Pullman a bad apple or the predictable product of a broken system? Should departments with always recording audio tell their officers it's active? Or is the deception justified because it reveals the truth? Rebecca filed an amended motion to dismiss on November 15, 2019. Attached to the motion were three things. 1. A transcript of Officer Pullman's conversation with Officer Hendricks. 2. A transcript of the locker room conversation. 3. A forensic video analysis comparing the body camera footage to the incident report. The analysis identified 14 specific false statements in Officer Pullman's report. Each one highlighted and cross-referenced to the timestamp that contradicted it. The motion was 53 pages long. Methodical, devastating, undeniable. Ada Jennifer Walsh received it on November 18th. She had 5 days to respond. On November 20th, she called Rebecca's office. The conversation was brief. We're dismissing the charges. No explanation, no apology, no acknowledgement of wrongdoing. Just a one-sentence concession that the case couldn't proceed. On November 22, 2019, all charges against Marcus Chen were formally dismissed. 8 months and 8 days after the arrest. 8 months of Marcus's life consumed by a lie. But the dismissal wasn't the end. It was the beginning of the real fight. On December 3, 2019, Rebecca filed a federal civil rights lawsuit. Marcus Chen v. Officer Derek Pullman, the city, and the police department. The complaint alleged 7 causes of action. 1. False arrest and imprisonment. 2. Excessive force. 3. Malicious prosecution. 4. Fabrication of evidence. 5. Failure to intervene. 6. Failure to train and supervise. 7. Municipal liability. The damages sought $2.5 million. Compensatory damages for lost wages, emotional distress, and reputational harm. Punitive damages to deter future misconduct. The city's response was predictable. Deny everything, assert qualified immunity, demand dismissal. Qualified immunity protects officers from civil liability unless they violate clearly established constitutional rights. The city argued that Officer Pullman's actions, even if mistaken, didn't cross that threshold. The argument is technical and maddening. Essentially, yes, the arrest was wrong, but it wasn't obviously wrong enough to strip away immunity. But Rebecca had something most civil rights attorneys don't. The officer's own words admitting fabrication. On March 3, 2020, the judge denied the city's motion to dismiss. The case would proceed to discovery. The city would have to produce documents, answer interrogatories, and make officers available for depositions. Depositions where they'd be asked under oath about quota systems and manufactured arrests. Where the code of silence would be tested in a conference room with a court reporter. The city calculated the risk. And on July 17, 2020, they offered to settle. The final settlement was $125,000. Paid by the city's insurance carrier. Officer Pullman contributed nothing personally. The settlement included standard language. The city admitted no wrongdoing. The settlement was not an admission of liability. Both parties agreed to confidentiality regarding settlement negotiations. But the settlement itself became public record. And buried in the agreement was one unusual provision. Officer Pullman would undergo additional training on constitutional policing and de-escalation. 8 hours of training. That was the accountability. Not termination, not suspension, not criminal charges for perjury. 8 hours in a classroom. Marcus signed the agreement on August 4, 2020. 17 months after the arrest. He received $125,000 before attorney fees and costs. After Rebecca's contingency fee and expenses, Marcus netted $73,000. $73,000 for 8 months of hell. For the trauma of being thrown to the ground. For 6 days in jail. For the fear that a criminal record would destroy his career. For learning that the system he believed in was designed to protect itself, not him. Is that justice? Officer Derek Pullman is still employed by the police department. He was not disciplined for the false report. He was not charged with perjury. He received a written counseling memo that will be removed from his file after 2 years. He completed the required 8 hours of training. And he returned to active patrol duty. As of January 2025, Officer Pullman has been involved in 4 additional use of force incidents. All were reviewed by supervisors. All were deemed justified. I requested the body camera footage for those incidents through public records requests. 2 requests were denied as part of ongoing investigations. 1 produced heavily redacted footage with audio removed. 1 has been pending for 11 months. The system protects itself. But there's one moment we haven't examined in full detail yet. The 30 seconds that defined everything. From the command to turn around to Marcus hitting the pavement. In part 4, we're going to slow it down. Frame by frame. Second by second. We're going to examine the exact legal statutes being violated in real time. The specific techniques Officer Pullman used and what the training manual says about them. The injuries Marcus sustained and what the medical records reveal. Because the overview tells you what happened. But the forensic detail tells you why it was a crime. Timestamp 23/47/22. This is where everything changes. Up until this moment, the encounter could have ended peacefully. Officer Pullman had Marcus's identification. He had run the name through dispatch. No warrants, no red flags, nothing. Marcus had answered every question politely. He had committed no crime, he had shown no aggression. But at this exact second, Officer Pullman makes a decision. A decision that will cost the city $125,000. A decision that will haunt Marcus for the rest of his life. A decision captured in perfect digital clarity. Let me walk you through it. Not at real speed, but at the speed of legal analysis. Every movement, every word, every violation. Because these 30 seconds contain at least 7 separate constitutional violations. And understanding them requires slowing down time itself. Officer Pullman's voice, turn around and put your hands behind your back. The command is clear, direct, non-negotiable. But here's the legal problem. Officer Pullman has no lawful authority to give this command. Under Terry v. Ohio, an officer may briefly detain someone for investigative purposes. But that detention requires reasonable suspicion of criminal activity. Walking on a sidewalk is not suspicious. Texting while walking is not suspicious. Being outside late is not suspicious. Officer Pullman claimed Marcus was trying car door handles. The video proves that was false. So the initial stop was already unlawful. But even if we accept the stop as lawful, escalation to arrest requires probable cause. Probable cause means facts sufficient to believe a crime has been or is being committed. What crime? Marcus asked this exact question. Officer Pullman had no answer. Because there was no crime. The command to turn around and submit to handcuffing is an arrest. Not a Terry stop, not a detention. An arrest. And an arrest without probable cause violates the Fourth Amendment. The violation occurs at the exact second. Before Marcus moves, before he speaks, before any physical contact. The constitutional violation is in the command itself. Marcus's response is immediate. His body language shifts. Weight transfers from evenly distributed to slightly back on his heels. His shoulders rise slightly, a startled response. His head tilts back incrementally, creating distance. And he takes one step backward. 8 inches measured from the sidewalk crack visible in frame. His voice, wait, what, why? This is not resistance. This is a natural human reaction to unexpected escalation. Psychologists call it the orienting response. When faced with sudden threat, the brain triggers an automatic assessment. Fight, flight, or freeze. Marcus doesn't fight, he doesn't flee. He pauses, questions, seeks clarification. The step backward is involuntary, instinctive. Watch his feet in the body camera footage. The left foot moves first, just barely. The right foot begins to follow but stops mid-movement. Because Marcus consciously overrides the instinct. He recognizes that running would be dangerous. So he stops himself. Total distance traveled, 8 inches. Total time elapsed, 9/10 of 1 second. But Officer Pullman interprets this as active resistance. And his training kicks in. Not de-escalation training. Not crisis intervention training. Control and compliance training. The kind that treats every hesitation as defiance. Every question as a threat. Every inch of distance as an escape attempt. Officer Pullman closes the distance. 2 quick steps forward. His right hand extends and makes contact with Marcus's left wrist. The contact is not gentle. The body camera captures the motion clearly. Officer Pullman's hand clamps down, fingers wrapping completely around Marcus's wrist. Thumb pressing into the radial nerve. This is a pain compliance technique called a wrist lock. Taught in defensive tactics training. Designed to cause sharp, focused pain that encourages submission. The training manual is specific about when this technique is authorized. Wrist locks may be employed when a subject is actively resisting or attempting to pull away. But Marcus hasn't pulled away. He took 1 step back and stopped. His arm isn't tensed, isn't retracting, isn't fighting. Officer Pullman applies the technique anyway. Watch Marcus's face at less than a second later. His eyes widen, his mouth opens slightly. The pain is immediate and intense. His voice, ow, wait. He doesn't finish the sentence. Because Officer Pullman is already escalating. Officer Pullman torques Marcus's wrist upward. The movement is sharp, practiced, efficient. It forces Marcus's hand toward his shoulder blade in an unnatural angle. The body's instinct is to move with the pressure to avoid joint damage. Marcus begins to turn. Not because he's complying with the command. Because his body is being forced into compliance by mechanical advantage. His voice, okay, okay. But Officer Pullman isn't listening. His left hand moves to Marcus's shoulder, gripping the jacket firmly. This is the setup for a takedown. Right hand controlling the wrist. Left hand controlling the shoulder. The training manual calls this establishing control points. But it also specifies that takedowns should only be used when 1. The subject is actively resisting. 2. Less forceful methods have failed. 3. Officer safety is at risk. None of these conditions are present. Marcus is turning, moving his hands behind his back. The words coming out of his mouth are agreement, not defiance. But Officer Pullman has committed to the escalation. And in modern policing, commitment to force rarely reverses mid-application. Marcus's voice, I'm not resisting, please. Listen to the tone. Not angry, not aggressive. Pleading. The word please is critical. It's not a word people use when fighting. It's a word people use when begging for mercy. Marcus's hands are moving behind his back. Slowly, yes, because his left wrist is being torqued at an angle that makes quick movement impossible. But moving nonetheless. His feet are planted, he's not trying to run. His body is rotating in the direction Officer Pullman is forcing it. This is textbook compliance. Verbal and physical submission happening simultaneously. But Officer Pullman continues the escalation anyway. His left hand pushes down on Marcus's shoulder. Hard. The pressure is visible in the way Marcus's knees begin to buckle. Officer Pullman's voice, "Stop resisting." But Marcus isn't resisting. He's submitting. And the command creates a record. A record that will appear in the police report as evidence of Marcus's noncompliance. Subject was given multiple commands to stop resisting. It sounds justified, until you watch the video and see that the commands are being given to someone who isn't resisting. This is the moment where Officer Pullman could de-escalate. Marcus is turned around. His hands are behind his back. His verbal communication is submissive. Officer Pullman could simply apply handcuffs from this standing position. It would take 5 seconds. No force required beyond the mechanical action of the cuffs themselves. This is what the de-escalation training recommends. When a subject is complying, match their compliance with minimal necessary force. But Officer Pullman doesn't choose this path. Instead, at 3 seconds after contact, he shifts his weight. His right foot moves behind Marcus's left leg. This is the setup for a leg sweep. A technique designed to take someone to the ground rapidly. The training manual is explicit. Leg sweeps are appropriate when a subject is actively fighting or attempting to flee. Marcus is doing neither. But Officer Pullman executes the technique anyway. Watch his left hand on Marcus's shoulder. It pushes downward with significant force. Simultaneously, his right leg sweeps Marcus's left leg backward. The combination is physics. When you remove the support structure and apply downward pressure, the body falls. Marcus has no time to react. No time to catch himself. No time to protect his face. Marcus falls forward. The body camera captures the descent in brutal clarity. His chest hits first. Then his face turns to the side, cheek striking the concrete. The impact sound is distinct. Not the soft thud of controlled descent. The sharp crack of unprotected collision. Marcus's breath expels forcefully. A grunt of pain and shock. His hands are still behind his back. Still in the position Officer Pullman commanded. Which means he can't break his fall. Can't protect himself. Can't do anything but absorb the impact with his torso and face. The medical report filed 3 days later will document the injuries. Contusions to the left cheek and jaw. Abrasions to the left shoulder and chest. Deep tissue bruising across the sternum. Lacerations to both wrists from handcuff application. But in this moment, Marcus is simply trying to breathe. Officer Pullman's knee lands between his shoulder blades. 207 pounds of pressure. Pinning Marcus to the sidewalk. Making it difficult to expand his lungs fully. Marcus's voice, "I can't breathe." Officer Pullman's response, "Stop resisting and you'll be fine." But Marcus isn't resisting. He's being crushed. Let me pause the timeline to identify the specific laws being broken. Violation 1, Fourth Amendment, unreasonable seizure. The arrest itself is unlawful from the moment Officer Pullman commands Marcus to submit to handcuffing. No probable cause, no articulated crime, no legal justification. Violation 2, Fourth Amendment, excessive force. The force used is objectively unreasonable under Graham v. Connor. The Supreme Court established 3 factors. 1, the severity of the crime at issue. 2, whether the suspect poses an immediate threat. 3, whether the suspect is actively resisting or attempting to flee. Crime severity, none, no crime was committed. Immediate threat, none. Marcus was compliant and unarmed. Active resistance, none. Marcus was submitting verbally and physically. Under Graham, the force is unconstitutional. Violation 3, State Penal Code Section 149, official misconduct. When a police officer uses force without legal justification, it becomes assault under color of authority. Officer Pullman committed assault. Not in the colloquial sense. In the criminal statute sense. Violation 4, State Penal Code Section 210.45, falsifying records. The incident report contains demonstrably false statements made with intent to mislead. That's a crime. Not a policy violation, not a mistake. A prosecutable felony. Violation 5, Federal Code Title 18, Section 242, deprivation of rights. Willfully subjecting a person to deprivation of constitutional rights under color of law. This is the statute used to prosecute criminal civil rights violations. Maximum penalty, 10 years in federal prison. But Officer Pullman was never charged. Marcus is face down. Officer Pullman's knee remains on his back. The handcuffs come out. Standard chain link restraints. Stainless steel with a double lock mechanism. At 7 seconds into the encounter, the first cuff closes around Marcus's left wrist. Each ratchet of a handcuff is called a click. Modern handcuffs have 16 possible click positions. The tighter the cuff, the more clicks engaged. Officer Pullman ratchets the left cuff 7 times. 7 clicks. The training standard is 3 to 4 clicks. Enough to prevent escape, but not enough to cut off circulation. 7 clicks is excessive. Marcus's voice, that's too tight. Officer Pullman doesn't respond. Doesn't adjust. Doesn't check. He reaches for Marcus's right arm. But Marcus's right arm is partially trapped under his body. Officer Pullman doesn't ask Marcus to move it. He wrenches it backward. The body camera captures Marcus's face contorting. Eyes squeezed shut, teeth clenched. The right cuff closes. 7 clicks again. At 15 seconds from the initial command, both hands are secured. Marcus is fully restrained. Helpless, and Officer Pullman keeps his knee on Marcus's back for another 11 seconds. Not for control. Marcus isn't moving. For dominance. For punishment. For demonstrating who has power. Let me describe what the audio reveals. The body camera's microphone is mounted on Officer Pullman's chest. It picks up everything within a 15-foot radius. When Marcus hits the ground, the impact registers. But so does something else. The scrape of fabric on concrete. The friction sound of Marcus's jacket dragging across rough surface. It lasts 1.3 seconds. That's how long Marcus's body is in motion from upright to prone. 1.3 seconds of uncontrolled fall. Then the breath sound. Forced exhalation, shock response. Then labored breathing. Short, shallow inhales. The rhythm of someone whose chest is compressed. Someone whose diaphragm can't fully expand. Then Marcus's voice. I can't breathe. 4 words that should trigger immediate action. 4 words that are policy-mandated warnings. 4 words that, post-George Floyd, every officer is trained to recognize as a medical emergency. Officer Pullman's response, stop resisting and you'll be fine. But listen to Marcus's breathing. It's not the pattern of someone fighting. It's the pattern of someone panicking. Respiratory rate increasing, hyperventilation beginning. This is the body's stress response to oxygen deprivation and fear. And Officer Pullman ignores it for 11 more seconds. 3 days after the arrest, Marcus visited his primary care physician. Dr. Sarah Mendez documented the injuries. Her medical notes are clinical and detailed. Patient presents with bilateral wrist injuries consistent with mechanical compression. Left wrist shows circumferential bruising approximately 2 centimeters in width. Right wrist shows similar pattern plus small laceration on radial side. Patient reports severe pain with movement and numbness in thumb and first two fingers. Assessment: likely nerve compression injury. Recommend nerve conduction study if symptoms persist. The photographs Dr. Mendez took are part of the civil case file. They show deep purple bruising circling both wrists. The bruise pattern matches the width of standard handcuffs exactly. This isn't the result of 3 to 4 clicks. This is the result of over-tightened restraints applied with force. The laceration on the right wrist is particularly telling. It's a half-inch split in the skin. The edges are clean, sharp, consistent with metal cutting into tissue. Marcus required 2 weeks of occupational therapy. He lost sensation in his right thumb for 6 weeks. The medical bills totaled $3,847. All for handcuffs that didn't need to be that tight. All because Officer Pullman chose punishment over procedure. Let me cite the specific training manual violations. The police department's use of force policy, section 4.2.3. Officers shall use only the force necessary to effect an arrest or detention. Violation: force used exceeded necessity. Section 4.3.1. Takedowns shall only be employed when a subject is actively resisting or poses a threat to officer safety. Violation: Marcus was compliant, no active resistance, no threat. Section 4.4.5. Handcuffs shall be applied with sufficient tightness to prevent escape, but not so tight as to cause injury. Violation: 7 clicks caused documented injury. Section 4.5.2. Officers shall immediately reassess the level of force being used when a subject complies with commands. Violation: Officer Pullman continued force despite compliance. Section 4.7.1. Officers shall provide medical attention when a subject reports breathing difficulty or injury. Violation: Marcus's breathing complaint was ignored. 5 policy violations. Each one documented in the department's own manual. Each one captured on video. Each one ignored during the supervisor's review. Because the system reviews for legal liability, not moral accountability. And Officer Pullman's actions, while brutal, fell within the broad discretion afforded to police. That's the real problem. We've examined 30 seconds. 30 seconds that violated 5 departmental policies and 4 criminal statutes. 30 seconds that caused physical injury and psychological trauma. 30 seconds that cost $125,000 in settlement money. But those 30 seconds don't exist in isolation. They're the product of a system. A system that incentivizes arrests. A system that protects officers who lie. A system that treats constitutional rights as obstacles instead of guardrails. In Part 5, we examine what happened next. The settlement breakdown, the officers' continued employment. The reforms that were promised and never implemented. And the question that haunts every case like this. If the camera shows the truth, why does the lie still win? August 4th, 2020. 17 months after the arrest. Marcus Chen sits in a conference room at his attorney's office. In front of him is a settlement agreement. 23 pages of legal language that reduces his trauma to dollars and cents. Rebecca Torres walks him through it page by page. The city is offering $125,000. Marcus stares at the number. $125,000. Is that what his dignity costs? Is that the price of being thrown to the ground for no reason? Rebecca continues, after our contingency fee of 33% in costs, you'll net about $73,000. Marcus does the math silently. $73,000 for 8 months of hell. For 6 days in jail. For the nightmares that still wake him at 3 a.m. For the panic attacks when he sees police cars. For explaining to his employer why he was arrested. For the shame of having his mugshot online forever. Rebecca slides another document across the table. There's a confidentiality clause. You can't discuss the settlement terms publicly. Marcus reads the clause carefully. He can't reveal the amount. He can't discuss the settlement negotiations. He can't speak about internal communications disclosed during discovery. But he can discuss the facts of the arrest itself. The body camera footage is public record now. The lawsuit is public record. The truth is public. The only thing being hidden is how much the city paid to make the problem go away. Marcus signs the agreement. His hand shakes slightly as he writes his name. Not from uncertainty, from anger. The $125,000 doesn't come from the police department's budget. It doesn't come from Officer Pullman's pocket. It comes from the city's liability insurance policy. The policy is underwritten by a company called Municipal Risk Management. They insure hundreds of cities against police misconduct claims. Last year, they paid out $47 million in settlements nationwide. This year, the number will be higher. The city pays an annual premium of $2.3 million for this coverage. That premium is funded by taxpayers. So taxpayers pay twice. Once for the insurance premium. Again when the premium increases due to claims. Officer Pullman contributes nothing. The police union contract specifically prohibits requiring officers to pay settlements. Even in cases of proven misconduct. Even in cases of perjury. The theory is that personal liability would make officers hesitant to act. Would create a chilling effect on law enforcement. But there's no consideration of the opposite effect. The effect of zero personal consequences. The effect of knowing you can lie in a report and face no financial penalty. The effect of understanding that the taxpayers will clean up your mess. Officer Pullman received the news of the settlement via email. He was CC'd on the final agreement. He responded with 2 words, "Sounds good." $125,000 is just the settlement payment. It doesn't include the city attorney's fees for defending the case. Those totaled $89,000. Billed at $350 per hour across 11 months of litigation. It doesn't include the cost of staff time. Human resources personnel reviewing Officer Pullman's file. Tech staff extracting and processing body camera footage. Risk management analyzing liability exposure. Estimated cost $23,000. It doesn't include the prosecutor's office time. Ada Jennifer Walsh and her staff spent approximately 60 hours on the criminal case. Before dismissal. Estimated cost $8,400. Total taxpayer cost $245,400. All because Officer Pullman decided Marcus looked arrestable. All because the system accepted his word without question. All because accountability is optional. Marcus received $73,000 after fees. The system spent $245,400. And nobody learned anything. Remember the settlement provision requiring Officer Pullman to undergo additional training. 8 hours of instruction on constitutional policing and de-escalation. I obtained the training records through another public records request. The training occurred on September 15, 2020. It was conducted by the department's internal training division. Not an outside expert, not a civil rights organization. The same institution that trained Officer Pullman initially. The curriculum covered Fourth Amendment search and seizure principles, 2 hours. De-escalation techniques, 2 hours. Implicit bias awareness, 2 hours. Report writing accuracy, 2 hours. The training was classroom-based. PowerPoint slides and discussion. No practical exercises, no role-playing scenarios, no skills assessment. At the end, Officer Pullman completed a quiz. 10 multiple-choice questions. He scored 9 out of 10. The training instructor marked him as satisfactorily completed. And that was it. That was the accountability. 8 hours that changed nothing. Because you can't train away a culture. You can't PowerPoint away impunity. You can't quiz someone into respecting constitutional rights they've spent 9 years violating without consequence. As of February 2026, Officer Derek Pullman remains employed. He was never suspended, never demoted, never reassigned. He patrols the same neighborhoods, carries the same badge, wears the same body camera that recorded his crimes. His personnel file contains the settlement as confidential legal matter. It doesn't describe what he did, doesn't acknowledge the constitutional violations, doesn't flag him as a liability. When the department conducts promotional evaluations, this incident won't appear as a negative mark, because the settlement included no admission of wrongdoing, because the city maintains the fiction that this was a legal disagreement. Not a crime, not misconduct, just a difference of opinion about use of force. Since the settlement, Officer Pullman has been involved in 4 additional use of force incidents. I filed public records requests for all 4. Incident 1, October 12, 2020. Traffic stop escalated to physical altercation. Subject charged with resisting arrest. Charges later dismissed. Body camera footage denied as part of ongoing investigation. Incident 2, February 3, 2021. Domestic disturbance call. Officer Pullman tased a subject who allegedly refused to comply. Subject hospitalized with injuries. No charges filed. Body camera footage released with audio redacted. Incident 3, July 19, 2021. Pedestrian stop for suspicious behavior. Subject handcuffed and detained for 30 minutes. Released without charges. Body camera footage pending review for 11 months. Incident 4, November 8, 2021. Welfare check turned arrest. Subject charged with obstruction and disorderly conduct. Case still pending. Body camera footage not yet released pending trial. 4 incidents, 4 escalations, 0 accountability. The pattern continues because the system allows it to continue. I submitted questions to the police department's Public Information Office. 14 specific questions about Officer Pullman's continued employment. Here are 3 of them. Has Officer Pullman undergone any additional discipline beyond the 8-hour training? Does the department track patterns of use of force incidents by individual officers? What reforms have been implemented to prevent similar incidents? The response arrived 6 weeks later. 3 sentences. The department takes all allegations of misconduct seriously. Personnel matters are confidential under state law. We remain committed to serving our community with professionalism and integrity. A non-answer designed to end the conversation. I followed up with a request for use of force statistics by officer. Denied as personnel records. I requested the department's early intervention system policies. Heavily redacted, unreadable. I requested the names of officers who have settled civil rights lawsuits in the past 5 years. Denied as invasion of privacy. The wall of silence is intentional. Transparency threatens the system. Questions led to scrutiny. Scrutiny leads to accountability. And accountability threatens the entire structure. Ada Jennifer Walsh filed charges against Marcus without reviewing the body camera footage. She fought the dismissal for 11 months despite mounting evidence. She never apologized, never acknowledged the error. And she was never disciplined. Because prosecutors have absolute immunity for charging decisions. Even when those decisions are based on false police reports. Even when they ruin innocent lives. The immunity is nearly absolute. Unless a prosecutor fabricates evidence or engages in outright fraud, they can't be sued. Can't be held liable, can't be punished. Jennifer Walsh prosecuted Marcus for 8 months. Cost him his freedom, his reputation, and his peace of mind. And faced 0 professional consequences. She's still a prosecutor. Still making charging decisions. Still accepting police reports at face value. still operating in a system that rewards conviction rates over truth. I reached out to her office for comment, left 3 voicemails, sent 2 emails. No response. Because prosecutors don't have to answer to the people they wrongfully prosecute. The system protects them too. Marcus Chen is 35 years old now. He still works as an accountant. He still lives in the same city. But he's not the same person. In a brief interview conducted for the civil case, he described the lasting impact. I can't walk at night anymore, even in my own neighborhood. Every time I see a police car, my heart rate spikes. I have to explain the arrest to every background check, even though the charges were dismissed. My wife says I wake up in the middle of the night sometimes, breathing hard. The technical term is post-traumatic stress disorder. Post-traumatic stress disorder from 30 seconds on a sidewalk. From handcuffs cutting into his wrists. From a knee on his back. From the realization that the law doesn't protect you. That compliance doesn't guarantee safety. That your constitutional rights are only as strong as the officer's willingness to respect them. Marcus sought therapy. 12 sessions with a trauma specialist. Cost $2,400. Not covered by the settlement. Not considered part of the compensable damages. Because psychological harm is harder to quantify than medical bills. The $73,000 he received is gone now. Some went to therapy, some to legal fees that the contingency didn't cover. Most went to rebuilding the life that was interrupted. Money can't buy back dignity. Can't erase the mugshot that still appears in Google searches. Can't undo the knowledge that the system failed him. Marcus's case only came to light because his family could afford Rebecca tours. Because Rebecca knew to request the raw audio files. Because the body camera happened to capture everything. But how many others weren't so lucky? I filed a public records request for all arrests in the precinct from 2019. 1,247 total arrests. I narrowed it to arrests where the only charges were resisting arrest, obstruction, or disorderly conduct. 89 arrests fit that criteria. 89 people arrested for no underlying crime. Just resistance to arrest that had no legal basis. I requested body camera footage for all 89. Received footage for 23. Denied for 61 as part of ongoing investigations or exempt personnel records. 5 requests are still pending after 3 years. Of the 23 videos I received, 18 showed similar patterns to Marcus's case. 5 showed legitimate resistance to lawful arrests. 18 out of 23. A 78% rate of questionable arrests. And that's just the ones I could verify. How many of those 89 people took plea deals? How many served jail time for crimes they didn't commit? How many have criminal records that will follow them forever? The system doesn't track this. Doesn't care to know. Because the answer would demand change. After Marcus's settlement, the city council held a public hearing on police reform. 3 hours of testimony. Community members shared stories of similar experiences. Activists demanded changes. Independent oversight of use of force incidents. Public database of officer misconduct. Discipline for false reports. Ban on arrests for contempt of cop. De-escalation training that actually works. The police union opposed every measure. Called them anti-police and dangerous. Argued that officers need discretion. That second-guessing in hindsight undermines split-second decisions. That reform would make the city less safe. The city council voted on 3 proposals. Proposal 1, create a civilian review board with subpoena power. Vote failed 4-3. Proposal 2, require annual use of force reporting by officer. Vote passed 5-2, but implementation delayed indefinitely due to technical challenges. Proposal 3, mandate body camera footage review before filing charges. Vote failed 4-3. Nothing changed. The hearing was theater. A pressure release valve that let the community vent without requiring actual accountability. 6 months later, the city increased the police department's budget by 8%. Hired 15 new officers. Purchased new equipment. And continued business as usual. Before I close this case file, I need to make something clear. This production utilized AI voice synthesis for narration. Some visual elements have been digitally recreated to protect identities. Certain names and identifying details have been changed. But the core facts remain true. The body camera footage is real. The settlement amount is real. The pattern of misconduct is real. I'm using these tools not to deceive, but to reveal. To tell stories that would otherwise remain buried. To give voice to people the system silenced. The AI doesn't change the truth. It amplifies it, makes it accessible, shareable, undeniable. Some will say this diminishes the authenticity. I say authenticity means telling the truth, regardless of the medium. And the truth is this: Marcus Chen was arrested for walking while black. Was brutalized for asking why. Was charged with crimes he didn't commit. And the system that did this to him continues unchanged. That's authentic. That's real. And that's what this channel exists to document. Let me give you the numbers one more time. $125,000 settlement paid to Marcus Chen. $89,000 legal defense costs for the city. $23,000 administrative costs. $8,400 prosecutor's office time. Total taxpayer cost, $245,400. $0 amount Officer Pullman paid. $0 amount Officer Pullman lost in salary or benefits. 8 hours total accountability training required. 0 criminal charges filed against Officer Pullman. 4 additional use of force incidents since settlement. 17-month time Marcus waited for justice. 0 reforms actually implemented. These numbers tell the story the system doesn't want you to hear. Justice isn't blind, it's expensive. And the people who cause the harm never pay the price. Marcus Chen versus Officer Derek Pullman. The criminal charges dismissed. The civil lawsuit settled. The officer's employment continued. The system's response silence. This case is resolved in the legal sense. The paperwork is filed, the money is paid, the case is closed. But in every sense that matters, nothing is resolved. Officer Pullman is still on the street. The prosecutor still has her job. The department still operates the same way. And somewhere tonight, someone else is being arrested for contempt of cop. Someone else is being thrown to the ground for asking why. Someone else is learning that constitutional rights are conditional. Someone else is becoming the next case file. The archives don't lie. The body cameras don't lie. The timestamps don't lie. Only the reports lie. Only the system lies. And the lie continues because we accept settlements instead of demanding accountability. Because we let badges hide behind qualified immunity. Because we value order over justice. Marcus Chen got his settlement. But he didn't get justice. Justice would mean Officer Pullman losing his badge. Justice would mean prosecutors who file false charges facing consequences. Justice would mean a system that protects citizens instead of protecting itself. We're not there yet, but every case file published brings us closer. Every body camera reviewed chips away at the wall of silence. Every story told reminds us that badges don't grant permission to lie. If you believe police reports should match reality, subscribe to Archives Resolved. If you believe settlements should come with accountability, share this video. If you believe the archives shouldn't stay sealed, leave your verdict in the comments. Was this justice or just expensive silence? Should Officer Pullman still be employed? Should the city have fought harder or settled sooner? Should Marcus have taken the settlement or pushed for trial? I want to hear from you. Because these cases don't resolve themselves. They resolve when we refuse to look away. When we demand that the digital record matters more than the official narrative. When we insist that 30 seconds of video outweighs 7 paragraphs of lies. The archives were meant to stay sealed. But not anymore. Case file 247. The officer wrote resisted arrest. The body camera showed complete compliance. The city paid $125,000. The officer kept his badge. The system remained unchanged. Case file 247. Resolved.